Hello students, today we are going to discuss on negotiable instruments and promissory notes. There are certain documents used for payment in business transactions and are transferred freely from one person to another. Such documents are called negotiable instruments like check, bank draft, bill of exchange, promissory notes, etc. Thus, we can say negotiable instruments are transferable documents where negotiable means transferable and instrument means document. According to section 13 of the Negotiable Instruments Act 1881, a negotiable instrument means promissory note, bill of exchange or check payable either to order or to bearer. Negotiable instruments are the common credit devices utilized in business society and in business transactions. Negotiable instruments acquired excessive importance because of their property of transferability and also because the transferee of a negotiable instrument may acquire more rights than would an ordinary as assignee. Though basically negotiable instruments are written promises or orders to pay money such as promissory notes, bill of exchange and checks. These instruments, if in proper form, may be transferred from person to person as a substitute of money. The law relating to negotiable instruments in India is incorporated in Negotiable Instrument Act 1881. The Act is not comprehensive. It does not affect the local usage or customs. The Act includes only 3 instruments in its ambit, viz. Bill of exchange, promissory note and check. But the Act will also be extended to other instruments possessing the characteristics of a negotiable instruments by local customs, for example, hundi. Negotiable instruments can be made payable by installments, bear a stated interest and have the additional advantage of being freely transferable to other creditors independent of any problems associated with the original transaction. While the use of negotiable instruments has fallen because of the growing use of credit cards, debit cards and the electronic transfer of funds, they still play a significant role in commercial transactions and consumer credit. Definition of a negotiable instrument. The Negotiable Instruments Act was enacted in India in 1881. Prior to its enactment, the provision of the English Negotiable Instrument Act were applicable in India and the present Act is also based on the English Act with certain modifications. It extends to the whole of India except the state of Jammu and Kashmir. Simple dictionary meaning of the word negotiable means able to be discussed or able to be passed from one person to another in return for something of equal value. Whereas the word instrument means a written document by which a right is created in favor of some person. Hence, negotiable instrument are all those instruments that can be easily transferable from one person to another in substitute of money. According to Business Dictionary, negotiable instrument is document of hire or the evidence of indebtedness that is freely transferable in trading as a substitute for money. They are the unconditional orders or promise to pay and include checks, drafts and bearer bonds, certificate of deposits, promissory notes and bank notes. Thus, negotiable instrument is a document that contains the specifics of what is promised to be paid. In other words, whoever possesses the instrument will be paid a specified amount of money on an agreed date. This date can either be immediate or sometime in the near future. Moreover, it can be transferred to a third party. In this case, the instrument moves to a new holder without any change in the value of it. For example, a check is a negotiable instrument. Suppose a person A gives rupees a check of 10,000 to a person B. The person B becomes a payee, that is a person to be paid the money. Person B takes this check to his bank and he has two options. Either he can get this check cashed or can deposit it into his account. We can define negotiable instrument as a document that contains a guarantee or promise to pay a specific amount of money to a person or entity in possession of the instrument, whether on a specified date or on demand, is known as negotiable instrument. A negotiable instrument features the name of the person who is to make payment. Examples are checks, banknotes and promissory notes. Today in this lecture, we are going to study the meaning of negotiable instruments with special reference to promissory notes. To begin with, we will understand the meaning and usage of these negotiable instruments, then know the characteristics, parties and other particulars of promissory notes. According to section 13A of the Act, negotiable instrument means a promissory note, bill of exchange or check payable either to order or to bearer, whether the word order or bearer appear on the instrument or not. In the words of Justice Billis, a negotiable instrument is one, the property in which is acquired by anyone who takes it bona fide and for value notwithstanding any defects of the title in the person from whom he took it. The term negotiable instrument literally means a written document which creates a right in favor of somebody and is freely transferable by delivery. A negotiable instrument is a piece of paper which entitles a person to a certain sum of money and which is transferable from one to another person by a delivery or by endorsement and delivery. Examples of negotiable instruments are negotiable instruments recognized by statute like bill of exchange, promissory notes and checks. B. Negotiable instruments recognized by usage or custom like hundis, share warrants, dividend warrants, bankers' drafts, circular notes, bearer debentures, debentures of Bombay Port Trust, railway receipts, delivery orders. Examples of non-negotiable instruments are money orders, deposit receipts, shared certificates, dock warrants, postal orders, etc. Characteristics of a negotiable instrument. First is property. One who possesses the negotiable instrument is the owner of the property contained in the document. A negotiable instrument is not just a possession of an instrument, but it is also a right to property. The property in a negotiable instrument can be transferred from one person to another without any formality. The difference is that in the case of a bearer instrument, the property is passed by mere delivery from the transferor to the transferee, and in the case of an order instrument, endorsement and delivery are required for the transfer of property. Title. The transferee of any negotiable instrument like a bill of exchange or a promissory note is known as holder in due course. A bona fide transferee for value is not affected by any defect of title on the part of the transferor or of any of the previous holders of the instrument. This is the main distinction between a negotiable instrument and other subjects of ordinary transfer. Rights. The transferee of the negotiable instrument can sue in his own name in case of dishonor. A negotiable instrument can be transferred from one person to another any number of times till it is encashed after maturity. The holder of the instrument need not give any notice of transfer to the party liable on the instrument to pay. Presumptions. Certain presumptions apply to all negotiable instruments. For example, it is presumed that there is consideration. It is not necessary to write in a promissory note the words for value received or similar expressions because the payment of consideration is presumed. The words are usually included to create additional evidence of consideration. Prompt payment. A negotiable instrument enables the holder to expect prompt payment because a dishonor means the ruin of the credit of all persons who are parties to the instrument. Moreover, the date of the payment is mentioned on the instrument. If the date is not mentioned, then it is presumed that it is payable on demand. It is payable at a definite time if it contains first, on a specified date, second, within a definite period of time, or third, on a date or a time readily ascertainable at the time the promise or order is made. In some instruments, there is an extension clause where the date of maturity can be extended by some definite period. For example, bill of exchange. Writing and signature. Negotiable instruments must be necessarily written and signed by the parties according to the rules relating negotiable instruments like promissory notes, bill of exchange and checks. A signature may be any symbol made by the maker or drawer with the present intention to be a signature. Negotiable instruments always contains a fixed amount of money and are payable by legal tender money of India. The liabilities of the parties of negotiable instruments are fixed and determined in terms of legal tender money. Negotiability. Negotiable instruments can be transferred from one person to another by a simple process called negotiation. In the case of bearer instruments, delivery to the transferee is sufficient. In the case of order instruments, two things are required for a valid transfer: endorsement, that is signature of the holder, and delivery. Notice, it is not necessary to give notice of transfer of a negotiable instrument to the party liable to pay. The transferee can sue in his own name. Special procedure. A special procedure is provided for suits on promissory notes and bills of exchange. A decree can be obtained much more quickly than it can be in ordinary suits. Popularity. Negotiable instruments are popular in commercial transactions because of their easy negotiability and quick remedies. Promise or order. A negotiable instrument must contain an express order or promise to pay. A mere acknowledgement of a debt is not sufficient without evidence of an affirmative undertaking on the part of the debitor to repay the debt. Presumptions about negotiable instruments. Let us see the presumptions provided by section 118 and 119 of the Negotiable Instrument Act, which are generally applicable to all the negotiable instruments. First, consideration. It is presumed that every negotiable instrument has been made or drawn or accepted or endorsed or negotiated or transferred for consideration. This holds both for the original parties as well as for subsequent parties. Second, date. In case a negotiable instrument bears a date, it is presumed that it was drawn on the date which appears on it. Third, time of acceptance. In case of a bill of exchange, it is presumed that it was accepted within a reasonable time after its date and before its maturity. Fourth, time of transfer. It is presumed that every transfer of a negotiable instrument was made before its date of maturity. Fifth, order of endorsements. It is presumed that the endorsements appearing on a negotiable instrument have been made in the order in which they appear on the instrument. Sixth, stamp. Unless the contrary is proved, it is presumed that A loss negotiable instrument was duly stamped. 7th, holder in due course. It is presumed that every holder of the instrument is a holder in due course. The parties are associated with negotiable instruments are maker or drawer is the one who directs the drawee to part. Drawees म्हणायचं ना, बरोबर आहे ना? Maker or drawer is the one who directs the drawee to pay a stated amount to himself or the third party who is the payee. Drawee, the person directed to pay the money by the drawer. Payee, one to whom money is or is to be paid. It generally follows the words pay to the order of. Holder is a person who is entitled for the possession of a negotiable instrument in his own name. Hence, he shall receive or recover the amount due thereon. Holder in due course is a person who has obtained the instrument for consideration and in good faith and before maturity. Endorser, a person or firm to whom a negotiable instrument like bill of exchange, bill of lading, delivery order or other document of title is transferred by endorsement. Endorsee is the holder in due course upon delivery of the endorsed document. He is also called a transferee or payee. Drawer in case of need. In addition to the drawee's name, the name of the person is given in the bill or end to be resorted in case of need. Such a person is called a drawee in case of need. Acceptor for honor. In case of refusal of acceptance of bill by the original drawer or in cases of providing better security when demanded by notary public with the consent of the holder, some other person who is originally not liable for payment of bill may accept it for honor of any party liable on the bill. Such acceptor is called acceptor for honor. So, let us have an overview of negotiable instruments. A negotiable instrument is a first written instrument, second signed by the maker or drawer of the instrument, third contains an unconditional promise or order to pay, fourth an exact sum of money with or without interest in a specified amount or at a specified rate, fifth on demand or at an exact future time, and sixth to a specific person or to order or to its bearer. Certain factors that do not affect the negotiability of the instruments are: first, if an instrument is undated, it does not affect its negotiability unless the date of the instrument is necessary to understand the payment term. Second, post-dating or antedating an instrument does not affect its negotiability. Third, interlineations and other written or typewritten alterations need not affect negotiability. Fourth, if the instrument fails to specify the applicable interstate, the judgment rate of interest defined by state statute becomes the interest rate on the instrument. Originally, there are only three types of negotiable instruments, namely promissory notes, bill of exchange and a check. After understanding various aspects of negotiable instruments, let us move to an important type of negotiable instruments that is regularly used in business transactions, and that is a promissory note. A promissory note is a financial instrument that contains a written promise by one party to pay another party a definite sum of money either on demand or at a specified future date. A promissory note typically contains all the terms pertaining to the indebtedness by the issuer or maker to the note's payee, such as the amount, interest rate, maturity rate, date and place of issuance and issuer's signature. A promissory note is usually held by the payee. Once the debt has been discharged, it must be cancelled by the payee and returned to the issuer. In its form, it usually contains a promise to pay at a time therein expressed a sum of money to a certain person therein named or to his order for value received. It is dated and signed by the maker. It is never under seal. According to section 4, a promissory note is an instrument in writing, not being a banknote or currency note, containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. Promissory notes are a type of negotiable instruments. Although a promissory note is defined in our Bills of Exchange Ordinance and certain parts of that statute is made applicable to them, strictly speaking, promissory notes are not bills of exchange. This is because promissory note involves only two parties, the maker of the note and the payee or bearer, while a normal bill of exchange involves three parties, namely the drawer, the drawee or acceptor and the holder. A promissory note must also be distinguished from a cheque. A cheque must always be drawn on a banker, while a promissory note need not involve a bank at all. Part 4 of the Bills of Exchange Ordinance of 1927 deals with the promissory notes. Suppose you take a loan of rupees 5,000 from a person called Rupesh. You can make a document stating that you will pay the money to Rupesh or the bearer on demand. Or you can mention in the document that you would like to pay the amount after 3 months. This document, once signed by you, duly stamped and handed over to Rupesh, becomes a negotiable instrument. Now Rupesh can personally present it before you for payment or give this document to some other person to collect money on his behalf. He can endorse it in somebody else's name, who in turn can endorse it further till the final payment is made by you to whosoever presents it before you. This type of a document is called a promissory note. There are primarily two parties involved in a promissory note. They are first the maker or drawer, the person who makes the note and promises to pay the amount stated therein, and second the payee, the person to whom the amount is payable. In course of transfer of a promissory note by payee and others, the parties involved may be first the endorser, the person who endorses the note in favor of another person, B, the endorsee, the person in whose favor the note is negotiated by endorsement. Thus, a promissory note is A, an unconditional promise in writing by one person to another signed by the maker, B, engaging to pay, C, on demand or at a fixed or determinable future time, and D, a sum certain in a money. E, to or to the order of a specified person or bearer. A promissory note is complete only upon delivery as given in section 86. Where a note is payable on demand, it must be presented for payment within a reasonable time as given in section 88(1). Where it is payable at a particular place, it must be presented for payment there. In any other case, presentment for payment is not necessary. Presentment for payment is necessary to make the endorser of a note liable as given in section 89. Some of the essentials or characteristics of a promissory note are: first, that it must be in writing. An oral promise to pay does not become a promissory note. The writing may be on any paper or book. For example, A signs the instruments in the terms that I promise to pay B or order rupees 500, or I acknowledge myself to be indebted to B in rupees 1000 to be paid on demand for value received. Both these examples are valid promissory notes. The second feature is that it must contain a promise or undertaking to pay. This undertaking to pay may be gathered either from express words or by necessary implication. A mere acknowledgement of indebtedness is not a promissory note, although it is valid as an agreement and may be sued on. Suppose A signs the instruments in the terms that Mr. B, I owe you rupees 1000, or I am liable to pay to B rupees 5000. These instruments are not promissory notes, as there is no undertaking or promise to pay. There is only an acknowledgement of indebtedness. On the other hand, if A signs the instrument in the terms like I acknowledge myself to be indebted to B in rupees 1000 to be paid on demand for value received, then it is a valid promissory note. The third characteristic is that a promissory note is the promise to pay, and this promise must be unconditional. The promise to pay must not depend upon the happening of some uncertain event, for example, a contingency or the fulfillment of a condition. Let us continue with our example, and suppose A signs the instrument in the terms like I promise to pay B rupees 500 7 days after my marriage with C, or I promise to pay B rupees 500 as soon as I can. Then these are not valid promissory notes, as the payment is made depending upon the happening of an uncertain event which may never happen, and as a result the sum may never become payable. On the other hand, if A writes, I promise to pay B rupees 500 on demand on 7 days from the date of signing the bill, then it is valid promissory note. Continuing with the characteristics, a promissory note must be signed by the maker. In other words, it is imperative that the promissory note should be duly authenticated by the signature of the maker, where, as explained in the features of negotiable instruments, a signature means the writing or otherwise affixing a person's name or a mark to represent his name by himself or by his authority with the intention of authenticating a document. As far as the maker is concerned, the maker, he or she must be a certain person, and the instrument must itself indicate with certainty who is the person or are the persons engaging himself or themselves to pay. Similarly, in a promissory note, alternative promisors are not permitted by law because of the general rule that where liability lies, no ambiguity must lie. As rules for makers are fixed similarly, the payee must be certain on the face of the instrument. A note in favor of fictitious person is illegal and void. A promissory note made payable to the maker himself is a nullity, the reason being the same person is both the promisor and the promisee. Let us proceed further. In a promissory note, the sum payable must be certain. This means for a valid promissory note, it is also essential that the sum of money promised to be payable must be certain and definite. Moreover, the amount payable must not be capable of contingent additions or subtractions. Let us make it more clear with the help of an example. Suppose A signs the instruments in the terms like I promise to pay B rupees 500 and all other sums which shall be due to him, or I promise to pay B rupees 500 first deducting thereout any money which he may owe me. These instruments again are invalid as promissory notes because the exact amount to be paid by A is not certain. person A will have to mention the exact amount that will be due and he will be paying to B on maturity or on demand. The amount that is payable in case of promissory note must be in legal tender money of India. This means that a document containing a promise to pay a certain amount of foreign money or deliver a certain quantity of goods is not a promissory note. To conclude, negotiable instruments have long played an important role in the world to reduce stress related to monetary and business transactions. These instruments have facilitated development of trade in and amongst developed, modern and sophisticated countries and developing and backward countries. Promissory notes as a type of negotiable instrument has proved to be a boon for these types of transactions. Thank you.